We do have some breaking news just coming in from the Supreme Court. I want to get straight over to CNN's Caitlin Polans, who's pulling together the details from us. And this has to do with President Trump's moves to freeze foreign aid. Caitlin, what's happened?
Yeah, Kate, what had happened in the Trump administration is they turned off money going to nonprofits and contractors on foreign aid, people that were working with the organization USAID, the agency that the Trump administration was trying to shut down. And what the Supreme Court, what Trump wanted to do is he wanted a green light from the Supreme Court to keep that money shut off. It's being litigated at the trial level courts far below the Supreme Court. And what the Supreme Court just said is, we're not going to do that. We need the lower court to figure this out. There was a judge there who had set a deadline for the administration to pay up $2 billion by midnight of a day last week, was giving them less than 24 hours to do it.
All right, folks, welcome to Dr. John Podcast right now. Days before his second inauguration, Trump begged the Supreme Court to erase his felony conviction, but the court ruled 5-4 against him, leaving him sentenced and carrying the label. He walked into the White House as the first president in U.S. history to be a convicted felon, 34 times over. Now, let me walk you through exactly what he was trying to pull, because the audacity of it is the story. Trump's lawyers went to the Supreme Court with an emergency request, a Hail Mary pass thrown from the 40-yard line with seconds left on the clock. They argued that as president-elect, he should not be sentenced at all. Their reasoning came in two parts. Part one, the public stigma. They literally argued that the embarrassment of being labeled a felon on the eve of his inauguration was so damaging that the court should step in and stop it. Read that again, folks. The argument was not that he is innocent. The argument was not that the trial was unfair in some fixable way. The argument was that being called what a jury already found him to be would look bad right before the big ceremony.
And the administration said, we can't just turn money back on like that. That's why we need the Supreme Court's help here to let us do what we want with our bills and just not pay them, freeze all the money that was outgoing. And now it's going to go back down to the lower court. But Kate, when you step back and look at what's happening in this order right here, it's 5-4, and the four dissenters of what is being done right now for Donald Trump, those people are all of the conservative justices, and what they are saying is, we can't believe that this Supreme Court is going to override what the executive wants to do here and just give this lower court trial judge, Judge Ali in Washington, D.C. on the district court, the power to figure this out right now. So a big struggle between the court system and Trump as president ongoing that we're going to keep seeing happen in the courts. Kate?
I was going to say, my take is like, this is not the last time this conflict and struggle is going to be playing out and making its way back to.
That was the pitch to the Supreme Court of the United States. Part two, immunity. They pointed at the immunity ruling from the previous year, the one that gave presidents sweeping protection for official acts, and said it meant a president-elect could not be prosecuted or sentenced while preparing to take office. It was a bold swing. They tried to turn the immunity shield into a get-out-of-sentencing-free card. And for a minute, it might have worked because this was close. This was one vote away from working. But it did not work. The majority, and this is the part that matters, included Chief Justice John Roberts and Justice Amy Coney Barrett. Barrett, folks, a Trump appointee. One of the justices his own movement put on that bench. She sided against him. The majority said the impact of a short virtual sentencing on an incoming president's duties was, in their words, fairly minimal, and that Trump could still pursue all his normal appeals down the road. In other words, this is not a big burden. Sit for the hearing and you can keep fighting later.
The Supreme Court, this is the beginning of a very long road here, but an important decision coming from the justices nonetheless. Caitlin, thank you so much for jumping on so quick for us.
Here with us to break all of this down. It's very, very significant. CNN's chief legal affairs correspondent, Paula Reed. This was an incredibly fast decision by the U.S. Supreme Court.
It was, and it's rare that the Supreme Court drops a decision on us at 9 o'clock in the morning. And look, this decision was pretty technical, but it really reveals a lot about the divides within the court itself. This is the second time that Trump's efforts to reshape the federal government have gone up to the high court. And here specifically, the Trump administration was asking the court to keep foreign aid frozen. But the court declined to do that. They actually sent that whole issue back down to the lower court to decide if those funds need to be released. Now, this is the second time that the Supreme Court has declined to intervene on Trump's behalf. But I want to note the larger questions about what Trump can and cannot do with DOJ, with this kind of foreign aid.
And on the immunity argument, they brushed it aside cleanly. Even if some immunity exists, they said, attending a brief virtual sentencing does not meaningfully interfere with the president's constitutional responsibilities. No special carve-out, no golden shield. Now here is the split that tells you how close this came. 4 justices, Thomas, Alito, Gorsuch, and Kavanaugh, wanted to give Trump the delay he asked for. 4. The conservatives were divided right down the middle, and Trump lost by exactly 1 vote. 1. That is how thin the line was between accountability and escape. So what actually happened at the sentencing? And here's the twist that makes this whole thing so fascinating. The punishment was basically nothing. Judge Juan Merchan signaled he would impose what is called an unconditional discharge. No prison, no probation, no fine, nothing.
Those questions have not been answered. The Supreme Court has not weighed in on what we call the merits or the larger constitutional questions. That's going to take some time. But again, twice they've asked the Supreme Court to help them out, and twice they have declined.
And basically, correct me if I'm wrong, the House of Representatives and the Senate both passed authorizing legislation for these billions of dollars in foreign aid. Then they passed separate appropriations bills, and then the president signed both bills into law. The Supreme Court saying, if you want to change that, there's got to be additional legislation on the Hill and more action by the president.
So I think eventually the Supreme Court will have to get at that issue. Right now, the issue they're deciding is really whether a district court judge can compel the administration to pay these billions of dollars in foreign aid that they're saying they don't want to. So it's interesting. There was a really lengthy dissent in this decision where 4 conservative justices were sort of outraged at the idea that a district court could compel the administration to do that.
Trump appeared by Zoom, visibly unhappy, sat through it, and walked away with 0 jail time. So the trolls will say, see, nothing happened. He got off. But come on, folks, that misses the entire point. The real punishment was never going to be a cell. The real punishment was that the sentencing happened at all. Because the moment that judge formally sentenced him, the conviction locked in. It became permanent. It became real, in the way only a completed sentence can be. As one legal analysis put it, the individual poised to lead the free world now possesses a criminal record that will follow him into the White House. No prison, but a scarlet letter that no pardon he can sign will ever erase, because it is a state conviction and a president cannot pardon those. Light sentence, heavy permanent label. That was the trade, and he could not stop it. And do not let anyone tell you the no jail outcome means the prosecutors lost.
Eventually, though, they will have to answer these larger constitutional questions that you just touched on. If Congress, appropriates these funds, can the administration just say, no, we're not going to send them out? Those questions will likely take a few months to get to the court because it has to go back to the lower court and work its way through the system. And the Supreme Court really isn't looking to jump the line right now.
Yeah, that would be the bigger constitutional question, right? What is the direct impact then of this?
So right now it's going to go back down to the lower court, and the litigation over this larger question will begin. And the district court can decide if the administration has to disperse these funds. I think what really stood out to me in this decision, though, is again, this is very preliminary. This is a very technical issue. We're not answering these larger questions yet about the separation of powers. But 4 justices, they all got together and they wrote a really powerful dissent. And what's notable about that is this is, again, like I said, it's not a minor decision, but it's not a massive decision. And the fact that they all took...
Or the judge went soft out of fear. The judge had a menu of options, and he picked the one that guaranteed the conviction would survive every challenge while giving Trump nothing to appeal about on the punishment itself. That is not weakness, folks. That is precision. A harsh sentence makes headlines for a day and then gets fought for years. A finalized conviction with no penalty attached is a quiet, permanent fact that just sits there in the record. Undramatic and undeletable. Trump would have traded almost anything for prison time he could rage against instead of a clean record he cannot. He did not get the choice. Every option in front of that judge favored the state in some way, and Merchan picked the one that closed the case tightest. Game over. So, in this video, I am going to break down the whole thing. How a man who dodged 2 impeachments got cornered by 12 jurors in Manhattan, why the Supreme Court refused to save him, what this felon status actually means now that he is in office, and why this quiet no-jail sentencing might be one of the most important accountability moments in modern American history. Because here is the thread that runs through all of it. For years, the story was that Trump always wins, always escapes, always finds the exit, and then a New York courtroom, backed by the Supreme Court, wrote 4 words into the permanent record of the United States that he will never be able to delete. Donald Trump, convicted felon. So buckle up, folks. Let's get into it. All right, let's rewind and build the whole picture. Because to understand why this ruling mattered so much, you have to understand what came before it and what always failed before it. Think about Trump's history with accountability. Congress tried twice. He was impeached in the House 2 separate times. The first over the Ukraine pressure campaign, the second over January 6th, and both times the Senate acquitted him. Why? Because conviction in an impeachment trial requires 67 votes, a 2/3 supermajority, and no president's party ever hands over that many senators. It is almost mathematically impossible by design. So impeachment as a tool kept proving the same lesson. It is a political process, and politics protected him. Twice the alarm was pulled. Twice nothing happened. And that fed the whole legend, right? The Teflon president. Nothing sticks. He beats everything. Every prosecutor, every committee, every scandal he walks. That was the brand. And honestly, for a long time, the brand was earned. He really did keep escaping. But here is what the impeachment escapes hid. There was never just one track for holding a president accountable. There were 3. Track 1 is impeachment, Congress, political, and we just saw how that plays out. Track 2 would be the 25th Amendment, the cabinet declaring him unfit, which is even harder and has never been used to remove anyone. But track 3, folks, track 3 is the one everybody underestimated. Ordinary criminal law, state prosecutors, a local jury, a trial judge, the same machinery that processes any citizen who breaks the law. And that track does not care about your poll numbers, your party, or your rallies. It does not need 67 senators. It needs 12 jurors and proof beyond a reasonable doubt. And in a Manhattan courtroom, that is exactly what the state of New York assembled. A jury heard the evidence about falsified business records, records cooked to hide hush money reimbursements tied to Stormy Daniels before the election. And they came back with a verdict on all 34 counts. Guilty, guilty, 34 times guilty. The track nobody feared turned out to be the only one that could actually land a punch. Now let's be precise about what those 34 felonies actually were, because the spin machine loves to muddy this. The charge was falsifying business records, and Trump's defenders love to say, oh, it is just paperwork. He called an expense an expense. It is nothing. Come on, it is not nothing. The jury found he falsified records to conceal payments meant to bury a damaging story before an election, dressing up hush money reimbursements as ordinary legal expenses to hide what they really were. Prosecutors laid out the evidence. The jury weighed it, and 12 people unanimously concluded it crossed the line from sketchy into criminal. 34 separate counts. And this conviction carries a distinction that will be in the history books forever. Folks, it made Trump the first president, past or future, ever convicted of criminal charges. The first in roughly 2.5 centuries of American presidents. Dozens of men, some of them involved in genuine scandals. Not one had ever been criminally convicted until this jury. That is not a small footnote. That is a line in the story of the country that can never be uncrossed. So by the time we get to that January moment, here is the situation. Trump has won the presidency again. He is days from inauguration, and hanging over him is his completed conviction, waiting only for sentencing to become final. And that is when his lawyers made their desperate run at the Supreme Court, because they understood something crucial. A conviction without a sentence is technically not final. Sentencing is the last break. Stop the sentencing and maybe the whole thing stays in limbo, gets tangled in appeals, fades into the noise of a new presidency. So they swung hard. President-elect should not be sentenced. Public stigma too damaging. Immunity ruling protects him. Article 2 duties would be burdened. Every argument they had thrown at the wall on an emergency timeline, hoping 5 justices would give them the delay. And you can understand the strategy. This court had been good to him. The immunity ruling months earlier had been a massive win. Why not expect one more? And picture the scene they were so desperate to avoid because the optics were genuinely historic. A president-elect days from taking the oath, forced to sit in front of a camera and be formally sentenced as a criminal. There's no precedent for that image anywhere in American history. No incoming president has ever had to do it. The founders never imagined it, Hollywood never scripted it, and Trump's team knew that once that image existed, once the sentencing was a completed fact rather than a pending threat, it would live forever. It would be the asterisk on his second term before the term even began. So this was not really a legal argument about burdens in Article 2. It was an attempt to prevent a historical fact from being carved into stone, and that is what makes the court's refusal so significant. 5 justices essentially said, "No, sir. The history books get to record what actually happened. You do not get to edit the ledger just because the timing embarrasses you." And here is where most people get this story wrong in both directions. You know the drill. One camp saw the no jail sentence and declared the whole thing a joke. No prison? Then it is meaningless. A total nothing burger. The system let him off, and I get the frustration. But that is backwards. The absence of jail time was never the measure. The conviction standing, the sentence landing, the label becoming permanent. That is the measure. And by that measure, the system did something unprecedented. The other camp went the opposite way. This proves the deep state got him. It is all rigged, a political hit job. But look at who ruled against him. Chief Justice Roberts, Justice Barrett, his own appointee. This was not some liberal cabal. This was a conservative majority Supreme Court. And the deciding votes came from the right. When the justices, your own side celebrated, tell you no, folks, the rigged story falls apart. The honest read sits between the two. A divided court by one vote refused to invent a special shield for one man and let ordinary criminal accountability finish its work. Not a joke, not a witch hunt. A line drawn narrowly that held. Let's break it down clean and clear so you understand what this ruling really did. The punishment was the process, not the penalty. I know this sounds strange, so let me make it simple. Normally when we talk about a sentence, we mean the consequence. Prison, probation, a fine. Here, there was none of that. Unconditional discharge. Trump walked away owing nothing and serving nothing. So where is the punishment? It is in the word convicted becoming the word sentenced. Until a defendant is sentenced, the case is not fully closed and there is wiggle room. The instant Judge Merchan completed that sentencing over Zoom, the conviction hardened into permanent historical and legal fact. It is on his record. It cannot be pardoned away because a president's pardon power does not reach state crimes. And this was a New York State case, so Trump is stuck with it for life. The man poised to lead the free world now carries a criminal record into the White House. The genius and the brutality of it is that by choosing no jail, the judge removed Trump's best argument for delay. You cannot scream that a Zoom hearing with no penalty is destroying your ability to govern. So the label landed precisely because the punishment was so light. Wild, isn't it? Think about the trap from the judge's side for a second, because it was masterful. If Merchan had thrown the book at him, prison, probation, a big fine, he would have handed Trump a legitimate grievance and a powerful argument that punishing an incoming president was interfering with the presidency itself. The appeals courts might have listened. The delay might have worked. Instead, by imposing essentially nothing, the judge removed every reason to pause. How can a hearing with no penalty possibly stop you from governing? It can't. So the conviction got finalized, the label got attached, and Trump was left with no leverage to fight the one thing he most wanted to stop. It was the legal equivalent of taking away someone's excuse before they can use it. Sometimes the softest possible punishment is the one you can least escape. This was the third accountability track, and it is the only one that worked. Remember the 3 tracks? Impeachment tried twice, failed twice, because it needs 67 senators, and party loyalty always saves the president. The 25th Amendment, never going to happen with a hand-picked cabinet. And criminal law, the track that needs no senators, no cabinet, no politics, just evidence and a jury. And here is the profound thing this case proved. Congress could not remove him. His own party shielded him. But a state prosecutor in Manhattan, a jury of regular citizens, and a trial judge could still convict him and sentence him, and the Supreme Court would not stop them. That reorders how we should think about presidential accountability entirely. For decades, the assumption was that impeachment was the main check on the president. This case says maybe not. Maybe the real check, the one with teeth, was ordinary criminal law all along, sitting quietly in a state courthouse, immune to the political games that neuter impeachment. Members of Congress can now say something they never could before. They are not debating alleged misconduct in the abstract. They are dealing with a president already convicted in a real court by a real jury. That changes every future conversation about his conduct. The felon-in-chief label and why it actually matters beyond the drama. Let's be real about the politics, because optics are power. For years, Trump's greatest asset was the aura of always winning, the strong man who beats every charge and walks through every wall. This ruling put a permanent dent in that armor because now his opponents have the simplest, most brutal message in politics. He is a sitting president and he is a convicted felon. That is not an insult. That is not spin. It is a fact a jury established in a court finalized, and it fits on a bumper sticker. Commentary and polling have long suggested that while plenty of voters will tolerate chaos, drama, and norm breaking, a chunk of moderates and suburban voters get genuinely uneasy about criminal status. There is a difference in their minds between a rule breaker and a convict. Now, did it stop him from taking office? No, he is president. The label did not block the door, but it follows him through every day of this term, in coverage, in debate, in the historical record, in the way the rest of the world's leaders quietly size him up. You cannot unring that bell. And every time accountability comes up for the rest of his presidency, that conviction is the concrete floor the whole conversation stands on. And here is a detail that makes it stick even harder. This being a state case, not a federal one, is the quiet masterstroke of the whole saga. If those falsified records had somehow been charged as federal crimes, Trump would control the Justice Department that prosecuted them. And a president has enormous power over federal cases, dropping them, pardoning them, pressuring prosecutors. But New York is not his to command. The Manhattan District Attorney does not answer to the White House. The state courts do not take orders from the Oval Office, and the pardon pen stops at the state line. So of all the criminal cases swirling around him, the one that reached a verdict and a sentence happens to be the exact type he has the least power to erase. Whether that was luck or strategy, the result is the same. Permanence he cannot touch. So where does this leave us? A few things. First, the pardon wall. Understand this clearly because people constantly get it wrong. Trump cannot pardon himself out of this one. Presidential pardons cover federal crimes only. This was a New York State conviction. It is beyond his reach, beyond any future president's reach. It is the state's business and it stays. That permanence is the whole point. Second, watch the appeals because his team said from day one they will fight on and they will. He has every right to pursue normal appeals, and he is pursuing them. Whether any succeed is a separate question, but the conviction stands unless and until a higher court overturns it. And for now, it stands. Third, watch how it shapes the accountability fights of this term. Any serious talk about his conduct now begins from an established fact, convicted felon, not from a hypothetical. That raises the stakes on everything. And fourth, watch the presidency itself, because the biggest legacy of this ruling may not even be about Trump. It is the principle that a president, sitting or incoming, is not automatically above ordinary criminal law, that the immunity shield, however broad, does not stretch to cover everything. A closely divided court just said the office is not a force field. That principle will outlive this presidency, and it will matter for every president who comes after. So let's land this plane. Here is your honest bottom line. Trump asked the Supreme Court to spare him from sentencing, and by a single vote, with his own appointee, Coney Barrett, and Chief Justice Roberts crossing him, the court said no. He was sentenced. He got no jail, no probation, no fine, and it did not matter, because the real consequence was the conviction becoming permanent. A state felony record no pardon can ever erase, carried straight into the Oval Office. 2 impeachments could not touch him. A hand-picked immunity ruling could not save him. But 12 jurors in Manhattan and 1 trial judge did what all of Washington could not. They made accountability stick. It was close, it was narrow, and the punishment on paper was almost nothing. But the label is forever, and the precedent may be bigger than the man. The Teflon finally caught on something, folks. Not in the Senate, not in Congress, but in an ordinary courtroom where the rules do not bend for anyone. And here is the thought I will leave you with. The immunity ruling told us there are limits to what courts will do to a president. This ruling told us there are limits to what a president can escape. Somewhere between those 2 lines is where the next 4 years of American law gets decided. And every time that line gets tested, I will be right here breaking it down. See you in the next one.